presentation in Spanish. Si usted habla español y prefiere escuchar en español, lo puede hacer por medio de Zoom. Tiene que estar conectado por computadora bajo el portal de Zoom para seleccionar la opción de interpretación. En el centro hay una barra de herramientas con varias opciones. Seleccione la que dice interpretación, haga clic y seleccione español.
Okay, look, I'm sorry, Lou, we're having some technical difficulties.
Okay.
Give us a second so Mary can catch up with the PowerPoint, okay? Okay, look, can you repeat the instructions in Spanish for folks?
Sure. Hey, sorry, we're having technical difficulties on my side. So just give me 1 second. Thank you so much. Thank you again for waiting. Si usted habla español y prefiere escuchar en español, lo puede hacer por medio de Zoom. Tiene que estar conectado por computadora bajo el portal del Zoom para seleccionar la opción de interpretación. En el centro hay una barra de herramientas con varias opciones. Seleccione la que dice interpretación, haga clic y seleccione español. María Murray estará interpretando la transmisión en español. Trala provides free civil legal services to low-income Texas residents in 68 counties of Central, South, Southwest areas. We cover different civil law practices such as housing, family, consumer, employment, and others. Okay, here we go. Let me introduce to you to the women who will be leading today's Power of the Hour, which is Ileana Riojas, who is the project coordinator for our community housing rights team, and housing attorney, Lisbeth Para Davila. Hi, ladies, how are you guys doing?
We're doing good. Thank you, Lou.
Thank you, Lou.
Thanks again, Lou, for the introduction and for everybody that's participating in our Tenant Rights Power Hour today. As Lou mentioned, we will be answering questions on basic tenant rights, repairs, eviction process, and additional resources available. Everyone is currently muted right now to get through this presentation, but there will be an opportunity to ask questions at the end. If you have a question, you can drop it in the chat or in the Q&A section at the bottom of the Zoom toolbar, or you can send us an email to write2counsel@trla.org, and that is RIGHTTOCOUNSEL@trla.org, or you can text us at 210-212-3703. And I believe that information should be in the chat for you all as well. A quick disclaimer before we get started that the following information, it's only legal information and not legal advice. Always look to your lease to ensure different rules don't apply. Due to confidentiality protections, we ask that you not share your personal information with us or ask any questions relating to your own personal legal matter. If you would like to apply for help from us, please contact us separately via email at write2counsel@trla.org, or you can always call us at 210-212-3703. Our lines are open Monday through Friday from 8 a.m. to 5 p.m. As you all know, currently the situations that most of tenants are dealing with or are faced, it's not only rent hardships, but also they've had to experience an eviction or threatened eviction, and possibly even homelessness due to the pandemic. Most recently, the Texas winter storm last month has left many tenants with repair issues, and some remain without power and water. We hope that the legal information we provide today is useful to you and that you share it with others as well. Okay, so let's get started. So to start off, Liz, can you give us a quick summary of what are the basic tenant rights?
Yes, Juliana. So thank you. Tenants, first, you have a right to proper notice. For example, such as a written notice of rent increases, notice of your lease not being renewed, and notice of receiving a notice to vacate prior to being sued for eviction. You also have a right to repairs that affect your health and safety. Unless you or your guests have caused the problem, you are not responsible for making repairs. You have a right to report issues, such as, for example, reporting a fire hazard to the code enforcement department or reporting violent conduct to the police department. You can also always reach out to your city council members or state representatives. You have a right to record your landlord without telling them. Texas allows you to record someone without their knowing as long as you are present. You cannot be forced to evict without a court order. You have a right to a court hearing. If you have a disability, you have a right to request a reasonable accommodation. For example, if you receive your disability income sometime in the middle of the month, you can request that they accept the rent late and waive late fees. Make sure to make the request in writing, and that whatever request you make is related to the disability. You have a right to do all of the things I mentioned without being retaliated against. Under Texas law, a landlord cannot decrease services, evict you, or not renew your lease if it's because you asked for a repair, participated in a tenant organization, complained to a government agency, or did anything else that you have the right to do. These protections are in place for 6 months. Remember, though, that no matter what, you have a duty to pay rent. Texas does not give tenants the right to withhold rent because the landlord is not providing certain services or not maintaining their property.
Thank you, Liz. As we mentioned earlier, last month, a lot of Texans faced the Texas winter disaster Uri that caused a lot of delays in repairs or unmet repairs from their landlord's end, such as burst pipes or even walls that need some repairs or roofing leaks. Can you go over how a tenant should address repairs after a disaster?
First, they should request the repairs by phone or online portal if that is available to them, and follow up with the written repair request. Landlords do not have to fix anything unless they receive a written request and the tenant is current on rent. You can drop off the request in person, but certified mail is preferred, and if you send by certified mail, you're only required to send it once. Even if you're not current on rent, make the request. Your landlord may still make repairs. Second, call your local code enforcement department to report the issue. Enforcement of code violations doesn't depend on whether you owe rent or not. And then finally, check your lease to see if anything is written about what happens in a disaster situations. And if you don't have a copy of your lease, ask your landlord for a copy. Your landlord isn't responsible for loss or damage to your personal belongings, so contact your renter's insurance if you have one, or apply for FEMA assistance to replace damaged personal property. The deadline to apply for disaster assistance is April 21st, 2021. Specify that your damages are a result of snow or ice and not a flood. If you've already applied and been denied, you have 60 days to appeal. Make sure to write down what you lost and take pictures or video record the damages. Keep copies of your FEMA application, receipts, and all disaster documents in one area.
So thank you, Lisbeth. So I guess the most important thing that I'm hearing right now is make sure that your requests are in writing to your landlord.
Yes, correct. Always document and keep copies of documents.
Okay, so to let the attendees know, to address the aftermath of the Texas winter disaster, TRLA has compiled several resources to address a wide variety of concerns from disaster assistance to renters' rights. So you can visit our website at www.trala.org/disaster. And the links will be placed in the chat as well for your convenience. Okay, Elizabeth, so what happens when damages by a disaster are many and the property is unusable?
So unusable properties can't be inhabited. That means that you may either terminate your lease or ask for a rent reduction or suspension if that is the case for you. To terminate your lease, send written notice anytime before repairs are finished. Be aware that you will still be responsible for prorated rent and other charges until you move out. Make sure to send a dated written request for your security deposit and include your forwarding address. And again, take pictures before moving out, because if there are damages to your property not caused by the disaster, your landlord could withhold some or all of your deposit. If you pay for your utilities separately, make sure to call the utility company so you can shut those off. And if your landlord terminates your lease, not you being the one terminating, they must still give you written notice. So if you do not want to leave or can't leave because of certain situations, they must still go through a formal eviction process to kick you out. Unless your lease specifically allows it, you can't get a rent reduction. You can only get a rent reduction if your landlord doesn't make the repairs you requested and you sue them. This is not the case for public housing residents. You can get a rent reduction if the housing authority doesn't repair your property within a reasonable time. Regardless, be sure to get everything in writing.
So what happens when they're just the damages are only a few and the property is actually usable?
So partially unusable properties can still be lived in while repairs are made. As long as you live at the property, you must keep paying rent. You can ask your landlord to reduce your rent because you aren't getting to use the full amenities. If you can't use walkways or pools, parking areas or laundry rooms, you can still make those requests. If your landlord agrees to a rent reduction, get a written signed agreement. If your lease doesn't prohibit rent reductions, you can sue your landlord to get a court order for reduced rent. But make sure to consult an attorney before doing this, as it is a rather difficult or sometimes needs a closer look at sort of process.
And just to remind attendees, you can always go to the State Bar of Texas to request a referral for an attorney, or you can reach out to us at Right to Counsel at trla.org. Okay. All right, so let's see. Can I get evicted during the COVID-19 pandemic?
Yes, so evictions in areas like, for example, Bexar County have continued. However, the Centers for Disease Control and Prevention, the CDC, issued an order that temporarily pauses evictions for certain tenants until after March 31st, 2021. Please keep in mind that this order does not forgive rent, and as a tenant, you're still responsible to pay rent, but we'll discuss a little bit more about the particulars of this protection later.
Great, thank you, Elizabeth. So can you walk us a little bit through how the eviction process works, or how do I know if my landlord's planning to evict me?
Yes, so the first step is getting a written notice to vacate before the landlord can file a lawsuit to evict you. This notice to vacate does not mean you have to move out. It just means your landlord will file an eviction case if you do not. You will know your landlord has filed an eviction case if you are served with an eviction citation by a constable or an officer of the court. The citation should include the time and date for your court hearing, include whether your trial will be in person or by Zoom, and the eviction petition, which includes the reasons for why you are being evicted by your landlord. As mentioned earlier, you have the right to a hearing, so it's important to show up to court, or a default judgment could be granted in favor of the landlord. If you lose, you have the right to appeal. You have 5 days to do this. And if you do not appeal, the court will likely grant a writ of possession, which is a final order that allows your landlord to remove you and your property from your home.
Okay, great. So what does the CDC order do?
So the CDC order protects eligible tenants from being evicted due to non-payment of rent until March 31st, 2021, if they provide a declaration to their landlord. This order does not cancel or forgive rent. It also doesn't prohibit landlords from charging late fees or other charges authorized in the lease.
How can one know if a tenant is eligible to be protected under this order?
So eligible tenants must submit a declaration to their landlord. To find out if you're an eligible tenant, you can visit our website where we have instructions and the form itself.
Okay, and I'm going to the website right now. Give me a minute. Sorry. Okay. So you can go to trla.org. Here we go. And to have no more information about the CDC, you want to go to this page, and this should be put on the chat for you all. You can also see this information in Spanish. Here you will find additional information on the type of evictions being covered, tenant eligibility, but most importantly, you will find sample forms that you can submit. So you can click here and it would download the form for you. And there's also instructions that you can use.
Yes, and once you sign it and submit that to your landlord, then you are protected under the order. Your landlord does not have to sign it, and you do not have to provide further documentation to your landlord. By signing a declaration, you are declaring under penalty of perjury that everything is correct. So if you sign the declaration when you know part of it is not true, you can be subject to severe criminal penalties. For non-citizens, these criminal penalties may have serious immigration consequences. If you have a court case, make sure to submit a copy of your declaration and let the court know you have submitted one to your landlord.
Great, thanks, Lisbeth. So do I still have to pay my rent?
Yes, the CDC order does not forgive rent. And if you provided a tenant declaration to your landlord, you've declared under penalty of perjury that you are using your best efforts to pay as much rent as you can. Also, if you are in court proceedings, you may end up with a larger judgment if no attempt to pay rent is made.
So speaking about paying rent, I hear that there are several rental assistance programs currently that tenants can look into. Can you provide some information on that?
Yes, currently there are 3 state programs providing assistance: the Texas Rent Relief Program, Texas Eviction Diversion Program, and the Texas Emergency Rental Assistance Program. In Bexar County, you can apply through the Neighborhood Housing and Services Department. Tenants should also apply to the Texas Rent Relief Program, as it provides up to 15 months of assistance and does not require a landlord to agree to participate. For more information on the eviction process and rent assistance available, visit stoptxeviction.org.
Are there any other kind of protections that landlord must follow during this time?
Yes, earlier I mentioned that tenants have the right to a notice to vacate. Typically, it can be for no less than 3 days, but for tenants who live in CARES Act covered properties, landlords must issue a 30-day notice to vacate before filing an eviction. To confirm if you live in a CARES Act property, check out our map, which is displayed on the screen and is located on our website or txcaresact.org. Also, a notice of tenant's right is required to be served with the notice to vacate issued in the city of San Antonio. The notice provides resources and information for the tenants. If landlords fail to provide this notice, they may be liable for a monetary fine of up to $500. However, there's a process to report this, so contact 311 if this is the case for you.
Well, thank you for this information, Lisbeth. So at this point, we're going to go ahead and open the floor to answer some of the questions that are being sent to us. Again, as a reminder, you can email your question to write-to-council@trla.org, or you can text it to our phone line 210-212-3703. So Lou and Mary, do we have any questions on our email account or texts that have arrived?
No, I have not seen any.
Okay. I just got one. Let me see. Okay. Okay, I have a question here from someone, Lisbeth. What happens if the landlord doesn't want to accept or apply from any of the local and state rental assistance programs?
If the landlord doesn't want to apply or accept, a tenant can still submit an application to the Texas Rent Relief Program. And if the landlord doesn't respond within the required time frame, then the tenant gets that assistance directly. So I recommend applying to the Texas Rent Relief Program and going through that process. It is lengthy, but again, that tenant gets the assistance directly if landlord doesn't approve or respond to any requests.
There's another question here. What should I do if I think my landlord claims he did not receive the tenant declaration or refuses to accept it?
So again, they don't have to accept it. You can submit it through several ways. So you can send it by email, you can send a text message, you can drop it off in person, or you can mail it and keep a copy. If you drop it off in person, take a video, take a picture, document in some way. And if you send it by email or text, make sure to keep that email or text so that if necessary, you can prove that you provided that. They don't have to accept it, so you can just drop it off and record yourself dropping it off. And that makes you, that protects you under the CDC order.
Okay, thank you, Lisbeth. There's another question here that came in. It's asking, what happens when a new landlord takes over an apartment complex? Do they have the right to ask us to leave within a few weeks' time?
So I will say it depends. There are situations where new landlords will come into play, and provided they follow the correct procedure, they could non-renew lease. I think if this is a situation that you're going through, I recommend applying for services through us so we can look into it further and provide proper advice. Just, either way, you remember you have the right to proper notice. And part of the proper notice includes knowing who your new landlord is. So they should be sending you correspondence saying, I'm your new landlord.
Okay, I believe that question was answered then. If you feel that your question wasn't answered, please send us an email or send us follow up with a phone call tomorrow or during the week, and one of our paralegals could open up an application for you for further assistance. Okay, the other question that I have is, are there any penalties for landlords that don't comply with the CDC order?
So there are penalties for not complying with the CDC order, the same penalties that apply to tenants who sign them without being eligible apply to landlords as well. So there are criminal penalties, and I think the federal government is actively investigating many cases like that.
Okay. There's another question that came in is asking that the water fees are included as part of the rent fee, but it seems that the landlord might be delinquent with SALS. Does SALS have the right to turn off the water of all the units without notifying the residents?
I would also recommend reaching out individually to apply for assistance.
Does the rental assistance program assist with relocation or to get access to a new place?
So I believe there is a part of the program where they're looking into providing that assistance for relocation. It might be a case-by-case basis, and I have not heard more information on whether that's being actively pursued. So I think TBA.
Yeah,
To be
I would also recommend for folks to reach out to NHSD, with the city of San Antonio. They might be able to provide additional information in regards to relocation assistance if available within the city limits. Okay. What happens if a tenant provides a tenant declaration, was served a notice to vacate during court hearing? Let me reread that again. Okay. What happens to a tenant who provided a tenant declaration, was served a notice to vacate and court hearing? And during the court hearing, it seems that it was favor of the landlord. So it seems that the declaration wasn't respected from what.
So if a court hearing happened and a declaration was found to be invalid because of certain situations, then and there's been a judgment against tenant, tenants have a right to appeal. They have 5 days to do so. They also can submit a new declaration after being in compliance. So for example, if the declaration was found invalid because tenant didn't make a best effort to apply for rent, well, then tenant can make a best effort by applying for rent assistance and then submitting a new declaration to the court. We have seen judges respect that, and we often recommend that be the process a tenant takes. But most importantly, if there is an appeal deadline and they want to appeal, they can do so.
Yeah, and just to add a little bit more on that, I think what this person's question meant is if they gave the landlord declaration before the court hearing or before the notice to vacate, I think one of the things that we did discuss that it's important for them to provide a copy when they're going to the court hearing.
Yes, really important to make sure that the judge has a copy and knows there was a declaration submitted.
Okay. So I think those are the only questions that I have here. One more, okay. How long do they have to give you to vacate the property?
So that depends on what property you live in. If you live in a CARES Act property, you have the right to 30-day notice to vacate before an eviction is filed against you. It also depends on your specific situation. So I would recommend applying for our services so we could look further into it if this is a situation you're running into. Typically though, 3-day notices to vacate are required unless your lease allows for less time, but no less than 24 hours.
Okay, our apartment managers in the past and current continue to refuse to renew our leases. Is that something that they could do legally?
So there is, I will go back to my always default answer, it depends. But in Texas, landlords are allowed to not release leases for any reason unless they're retaliating against you. So if you feel they are not renewing your lease or terminating your lease, because you submitted a repair request or filed a CDC declaration, or some other reason that's retaliatory, then you can raise that as a defense, and those protections are in place for 6 months. So you should not have your lease non-renewed because of a retaliatory reason. But again, I'll make sure to apply so we can look further into it.
I think you might have addressed this next question, Lisbeth, but I'm gonna reword it again. If your apartment complex is planning to shut down for either rehabilitation, repairs, or no further type of commerce, and is asking everyone to vacate, how long do they have to give you to be able to move out?
Yeah, I think same reason. It will depend if the property is completely uninhabitable because of, for example, disasters, then depending on your situation, your landlord may be able to terminate your lease. They still have to take you through the eviction process though if you cannot leave. If it's a non-renewal just because they're selling the property, not retaliatory. Typically, a non-renewal is 30 days, but highly depends on your lease and where you live at. Some properties have additional protections and some do not.
Okay. Any other questions? Mary Ann Lou, on your side?
We have another question, and they want to know how you can stop an eviction.
I mean, if you are an eligible tenant and submit a CDC declaration, that may stop an eviction. It's I don't know. There's no clear answer to that. I'm sorry.
Like, I believe it pauses it, right? Because I do have a follow-up question on that. That what happens after March 31st, when this order is set to expire?
That is unknown. We have not heard that it would be extended, or we have not heard of an extension. And so what may happen is courts will start setting hearings that have been paused and then follow with new eviction filings. But at the moment, that's all we know. There has been no other notice by the Texas Supreme Court on that either.
And for folks that want more details on the eviction process and what the appeal process is, and even look for sample pro se forms, I do want to suggest for you all to visit our legal resource website at trla.org under the housing section. You will find a video in English and in Spanish walking you through the eviction process, the appeal process, and also provide you with sample pro se forms that you can use and file yourselves. Okay, so I believe that's it. So, okay, so let's go ahead and to wrap this up, let me go ahead and share some of the local resources that are available. Okay, give me a second. All right. So again, you can visit our website at www.trala.org for legal resources, sample forms, and instructions on the eviction process and other renters' rights or housing issues. So sacred.org is the website where you can find out what housing, food, or any other needed assistance is available within your 5-digit zip code area. We also suggest that you reach out to your local utility service provider to see if you could get in a deferred payment plan for needed utility assistance. SALS also has a donation repair fund called the Community Pipe Repair Program that will help qualified homeowners and renters repair freeze damaged pipes and restore safe water service. For more information, please visit their website at www.sals.org/CPR. And within the San Antonio city limits, residents can reach out to the Neighborhood and Housing Services Department from the city of San Antonio. They are currently providing rental, mortgage, and utility assistance. You can apply online, and their website is www.sanantonio.gov/NHSD. The link will be placed in the chat as well. Or you can also reach out at 210-207-5910. And again, the state of Texas Rent Relief Program is providing rental relief assistance. And you can visit their website at texasrentrelief.com for further information, or also reach out to them at 833-9TX-RENT. The City of San Antonio Emergency Resource Call Center, also known as the ERCC, provides assistance to residents affected by the 2021 Texas severe winter storm. San Antonians can call 311 or select option 5, or they can dial 210-207-6000 to connect with an intake person. They can also apply online at strongertogether.sanantonio.gov. They are open Monday through Friday from 8 a.m. to 5 p.m. as well. So that's it for us. Thank you all so much for joining. If you feel like you have a question or would like to follow up for additional advice in regards to your personal legal issue, you can always apply with legal aid by emailing right to counsel@trla.org or reaching out at 210-212-3703. Thank you all for joining us, and please remember to share what you learned today with others. Have a good evening.
Thank you.